Hi everyone, welcome to our session today, which is a bit like the last one but not a lot like the previous ones because we're on Zoom, but good to see you all here. So welcome to keeping your staff safe in the workplace and beyond. So we're going to cover off a few things today. There's obviously a focus on flexibility in working that's around particularly post-COVID, and then of quite a few issues arising around the workplace and beyond the workplace that we're going to focus on today. And then we will touch on some cases that have come out of COVID. There's been a couple of cases that have commented on that. So we'll launch into it. So before we head off onto all these various topics, it all sits with the under the health and safety framework. So it's always quite useful to remind ourselves of the principles there. So of course the starting point is the Health and Safety at Work Act. And that sets out various duties and various entities and what their obligations are. So the first is your PCBU. You should all be familiar with that terminology by now, which has the primary duty of care to ensure the health and safety of workers and others, which this diagram quite nicely addresses. Officers, of course, people like directors, if we're talking about a company, but also things like trustees in a trust or partners in a partnership, and basically your governance roles. It also includes the chief executive or high-level position who has an influence over the company. And those officers need to ensure due diligence. And the logic behind that being that the officers are usually the people and they make sure that the PCBU does what it should to ensure health and safety. So that's really our sort of, in a nutshell, our starting point. There's lots of principles around what you should and shouldn't do, certainly around first trying to eliminate risk, but we know that that is not always the answer. That often we are looking at minimising and applying controls to make sure that things people are protected, etc. And the practical elements around that we'll get into as we talk under each of the topics. It's important to remember, though, that cost cannot prevent steps that might need to be taken. It might be that you don't need expensive and time-consuming measures in place if we're talking about a low likelihood with low impact. But if on the other end of the spectrum, we're talking about a much higher impact or a higher likelihood, then we might need to be applying some more controls, and they may be more expensive. If you're picking something that is a low-cost option simply because it is cheaper, then it's not going to end very well, particularly if WorkSafe gets involved. We thought it might be quite useful just to talk about a couple of cases and the directions that they have given, not in massive detail, but the first being WorkSafe's prosecution of the Ministry of Social Development arising out of the shootings in the office in Ashburton, which you'll all be well aware of. So in that context, the court made it clear that employers need to assess the level of risk that their staff are facing and what steps would be appropriate for them and their workplace to manage that risk. So if you will recall, that case was brought by WorkSafe due to its concerns that there weren't proper processes and structures in place to protect the workers of that office from people walking in off the street. So the court identified 6 practicable steps that MSD should have taken to protect its workers. Now, these were particular to the situation and dealing with high-risk clients, but there are a number of these aspects that we can pull out and apply to many instances in which we're dealing with staff. So they were ensuring there was no physically unrestricted access by clients to the staff working area, ensuring employees and contractors were adequately trained to respond to an emergency response incident, adopting a zero tolerance policy with regard to securing and embedding policy in workplace culture, implementing client risk profiling and client management plans tailored to the risk from that client. So those are things that are not going to apply to everyone. Implementing effective incident investigation. So those are just some things that you can reflect on in terms of your everyday work and your work environment. Another prosecution involving AFCO related to a worker who was cleaning up an offal spill where raw material squirted into the employee's eye, and they weren't wearing safety glasses or any sort of protection around the face. And the worker became incredibly ill with this bacterial infection that's carried by animals and required quite significant surgery and replacement bits of eyes. So workplace investigated that and saw that AFCO had highlighted the risks from these infections, and including putting it in their hazards register, but didn't actually put in place control measures. So that's a basic thing to think about. You know, when you're identifying hazards, that's one thing, but make sure that you're actually doing something about it. And of course, the consequences being that there are significant penalties. When the Act came in, the new Act, which is now a number of years old, the penalties were increased. So individuals who are not PCBUs have potential maximum 5 years imprisonment or $300,000, and companies who are PCBUs, 3 million. So, you know, that's for the most reckless behaviour, but it is, the stakes are high in health and safety. So I'll hand over to Anthony to talk about work-related health.
Thank you, Amanda. Look, a healthy workplace really should be at the centre of any business's operation, but it's not just health. It's health and well-being. And I've just set out in this slide some examples of the kinds of things that you need to have in the back of your mind. Like, for example, physical risks. Well, we all know the physical risks of dealing with a dangerous chainsaw. So those things are pretty obvious. Some of the less obvious things, and Amanda's touched on it with that MSD case, the physical setup of your office. Is it a safe physical setup? You know, can members of the public easily gain access to your office? Are there any controls in place? And a number of years ago, and I think I've spoken about this, a client of ours had an incident in its office where the wife walked into the office and had free access past reception straight into a work area to remonstrate with another female employee about her relationship with her husband. It caused quite a scene, as you can imagine, but that woke this particular employer up to look at its physical structures, its physical risks that it might need to manage. So those are the kind of things that you might need to think about in the broader context. The ergonomic risks, well, we all know about those. You know, manually handling lifting, your desks, you know, if you've got staff that are seated at a desk for long periods of time, you know, you may need to look at standing desks. So those are the kind of risks that you should be exploring. Social risks. Now that's your bullying, your harassment, you know, excessive workload can fit into that. And we all know when you have those kinds of things, they can result in work-related stress, even depression, and they're risks that you need to manage. Impairment risk. really, that's quite a developing area, and I'm going to come on to my next slide to talk a little bit about just managing general well-being shortly. But, you know, what have you got people in your workplace that, say, for example, suffer from diabetes, and as a result of that, that causes them, you know, severe hypoglycemia, and so they become unwell at work. So how do you manage that? What about people that have heart conditions? They impairment risks. And then I've highlighted also incapacity. Incapacity, that's really an interesting one. It can be a number of issues that you need to manage within your workplace. I also should probably have mentioned within impairment, the obvious ones, you know, the drug, alcohol, fatigue, those kinds of things as well. Well, they're all things that you need to keep in mind in your modern workplace today, and have plans of how you might deal with those things. Right, I've put up here a chart which I hope you might find useful. In this chart, I've highlighted some of the issues that, you know, from a good worker health perspective. Promoting good health, which is above the centre line, and I'll just in a minute take you through this diagram, such as, you know, healthy lifestyles, through to healthy protection, which is the work-related health risks. So things below the line are pretty obvious health and safety protection, making sure that you have safe working conditions for your workers. The less obvious one is the health promotion, and where your duties may or may not lie in respect of that. So that's slightly different, and I simply just say in relation to that, you might want to have a policy of encouraging your staff to go to the gym, go for a walk at lunchtime. Those kinds of general policies may help in terms of your healthy environment. These are all voluntary, and as I've shown in this chart, above the line is all voluntary. The general well-being, the general resilience. I know there's plenty of organisations in the marketplace that can help businesses with building worker resilience to a range of stresses that you suffer in your everyday life. And they're all the good things that you may want to consider in terms of your general approach to looking after your staff. So there's nothing really hugely magical there, but I thought this chart might be useful. Put it in your bottom drawer and have a look at what you kind of can and can't do. Obviously, in the far right-hand columns, I've talked about what WorkSafe might do. Certainly below the line, WorkSafe's policies around that, you know, they will engage, educate, and in some cases prosecute or enforce, as I've said there. Above the line, the WorkSafe may encourage a PCBU and its workers to adopt a healthier workplace.
Yeah, and well, just in when the Act first came in, they were very much about education, but you can see by the number of cases coming through that they've very much moved to that enforcement stage, haven't they?
Yeah,
in terms of those under the line matters.
Yes. That's all I really wanted to say on promoting that or protecting. So have that in the back of your mind.
Okay. So another aspect about keeping staff safe is around family violence. So this new legislation came in about a year ago, and about protecting employees and the obligation that employers have to protect workers in relation to family violence and provide them with certain entitlements. So important to remember, of course, that family violence has a very wide definition. So it's not just physical, it also includes sexual and psychological abuse. Some, of course, with you can't always see the impacts of these matters, and it's incredibly sensitive topic. So there is in legislation the ability for those employees who are affected by family violence to have at least 10 days of family violence leave, and to ask for short-term flexible working arrangements of up to 2 months, and to not be treated adversely in the workplace. Specifically a point of discrimination in relation to family violence. So employees, it's similar in terms of qualification to your sick and bereavement leave, in that they need to have been continuously employed for 6 months and on an average of 10 hours a week, or at least an hour every week. Or 40 hours in every month. So that bit's a bit like your parental leave. So we're meshing a whole heap of concepts and not reinventing the wheel. So in terms of the leave, so if you're there for less than 6 months, then you're just not entitled to the leave. And then once you qualify, then 10 days is the minimum entitlement. And there's no obligation to carry that over, for example, if it's not used, or to pay it out on termination. So how do they use it? As early as they can, just like all other leave, they need to tell you that they want to take domestic violence leave. Now, employers can require proof, and you may have heard me say this before, that is something to take care about. So proof is purposely not defined. So it could be something from a medical practitioner, a family violence organisation, the police, or some other organisation with whom the employee has been working. There is a school of thought that is being put out there that the asking of proof is just another difficult point for people who are already in a very difficult situation. So that is something for employers to think carefully about. But the legislation does provide that the employer can require proof, and that the employer does not need to pay the employee for that leave until they get the proof, unless there's a reasonable excuse. In terms of the flexible work, it's a familiar regime, so to what we are used to. So employers can ask for changes to hours and days of work, the location in which they work, and their duties at work. So that might, the duties at work, for example, could be to move them away from a public-facing aspect of their role, for example. Other things might be changing start and finish times so that they can't be located easily. So there could be a variety of requests there. So this is in addition to your general flexible working requests that can be made. So it's specifically to address domestic violence, and the employee has to specify a number of things around what you would expect, things like the what they're requesting, what they're asking to change, how long they want it to last for, and all of those sort of logical things, which are spelt out in the Act. The employer is obliged to provide a response in 10 working days, and if you don't, then you can't decline it. So you need to get on with it and deal with it as soon as it comes in the door. Once again, entitled to request proof, and the same matters apply there. There is the ability to decline a request, and they are on grounds that we're familiar with seeing, which are inability to reorganise work amongst existing staff and to recruit additional staff, things like impacts on quality, performance, financial implications, etc. So those are in place. In terms of managing all of this, a really good starting point is to have a family violence policy, and one that spells out quite carefully the processes and the entitlements. Now, we don't always spell everything out in a policy because that is what is spelt out in legislation. But given the nature of this, and that employees are unlikely to want to walk up to someone and say, what are my entitlements, given that this is occurring in my life. So it's one of those areas where we suggest it's good to put more into these policies so that they can have access to that information. And there is a requirement, even if you are declining a request, to provide certain information to them about support that is available for them. So that is an obligation that's been placed on the employer. So that is a really key area for keeping staff safe. That is something to bear in mind when you're dealing with your staff.
Right, I'm going to talk to you about pivoting, because that's one of the buzzwords that came out of our COVID experience. Everybody's been pivoting.
No. Can you imagine these ballerinas and all sorts pirouetting though?
Pirouetting around.
Yeah.
Look, working flexibly. Many businesses have achieved that over the COVID period very, very well, and in some cases it's worked well, and employees are now starting to look for more permanent changes to their terms and conditions of employment so that they can work remotely. The Employment Relations Act is your starting point, and it provides for separate flexible working arrangement regimes, kind of similar to what Amanda's just talked about in the family violence situation. So, but there are some differences and some fishhooks here. So, firstly, we recommend that you have a policy in dealing with flexible working arrangements or remote working arrangements, and there's some good reason. That policy should cover a range of things, everything from health and safety, which is what this is all about today, through to welfare issues, through to how you might just get the work physically done, right down to confidentiality, privacy. All of those kind of issues are important, and even monitoring. I recently saw something in the media about employers during COVID-19 monitoring the keystrokes of their employees to check whether they're actually at their screens. And that raises of itself issues, productivity. So it's not a straightforward issue. There are some real complexities. One of the things I would like to talk about is once an employer agrees to implement a flexible working arrangement, one of the problems in the Act is there is no mechanism to rescind that amended agreement. And so you need to bear that in mind and approach flexible working arrangements very, very carefully. I suggest that you do a full and proper assessment of whether that's going to be feasible in the longer term, and that's exactly how you want to run your business. If it is, that's fine. But I'm saying I think you should approach it with some degree of caution. Conduct a risk assessment, of course. So that might be going out to the workplace of the employee, maybe their home, to make sure that they have suitable equipment available, the obvious one. There are fire and general electrical safety issues that you might need to look at. What's the setup they have at home? Is it ergonomically suitable? Those kinds of issues. And then just do a general health assessment of those kinds of risks. One of the risks that came out of working remotely is this issue of isolation, and employees feeling isolated, which was affecting their well-being. Now, that's obviously something that you're going to need to monitor as employers, and monitor that quite regularly. What would that mean? Do you do home visits regularly? How do you manage that? So these are all kind of questions that you need to have in the back of your mind. You need to explore with the employee when you're sitting down and doing that assessment. Yes, I'm happy for them to work at home. One of the other problems is if you do agree to that, does it become permanent? You have an employee that might want to work occasionally from home because it suits them, and that's fine too. But does that flexibility become permanent in some way so that they can rely on a variation to their employment agreement? How does it affect your business? What's the productivity issues that may arise? If it works, it's great. If it doesn't, then you need to have mechanisms and a policy on how you might address it. And they're important issues. I'm suggesting that you should do regular visits to those employees that are working remotely, just to check in on them, to make sure that those practical things, like their workplace is set up properly, the hazards are identified and managed, and more importantly, that the well-being of the employee is considered as part of that process. Privacy considerations. I just want to touch on that just briefly. So if you are sending confidential information or expecting the employee working remotely to maintain confidentiality, or is dealing with sensitive documents or information, how will you manage that? What controls will you put in place? For example, let's say they've got a printer at home and they have hard copies of information. How will they be disposed of? Will they go out in the employee's rubbish bin, or will you send them back to the office for shredding? You know, those are those practical considerations which you may need to have in the back of your mind. I need to deal with them. I touched on earlier the monitoring. To what degree will you monitor employees where it doesn't become creepy that you're constantly, you know, looking down the camera at them to make sure that they're in front of their screen, or are there other mechanisms? And so those are the discussions that you need to have with the employee, that you will check in on them and you will monitor the work that they're producing, so that it isn't creepy and everybody understands what the rules will be. Those are just some practical considerations for you to think about. And then we get into the bullet points on this slide. Hours and days of work, what will they be? Where will they work if it's from home or some other location? And what will the duties be? All of those things may require a variation to an employment agreement. It is best that you get that variation recorded in writing so everybody understands what's required of the employee and of the employer, and get it signed. That's what I want to say on that, Amanda, I think.
Yeah, and I guess that comes back to the importance of the policies, isn't it? That, you know, all of those things, recording them so that it's no surprises.
Yeah.
And it is different from when we were all forced under, you know, emergency legislation to stay at home. That was different. We had, that was a requirement of the government. Now we're in a different realm, and the answer a lot of employees are saying is, well, it worked fine during COVID.
Yep.
But remembering, of course, no one was in, well, that's not correct unless you're an essential worker, but if you think of an office situation, everyone was out of the office, and the difficulties of having some in, some out meetings that are now expected to be in person, but we all say we love Zoom. So, yeah, there's lots to think about, isn't there?
Yeah, and look, don't get me wrong, employers can say no.
Yes.
But there are limited grounds of challenge to that. But, and again, if you want some advice on that, and come back to Amanda or myself in relation to saying no.
Yeah. Next topic, outside an office. So just remembering, of course, that the workplace is not just the building where the business operates from or the organisation operates from. So the workplace is anywhere where work is carried out, and anywhere that the employee goes or is likely to be going while at work. So there are lots of jobs that are wandering around the place, aren't there? So there are things like field workers, you know, people who are contractors in the sense of the trades are all out and about, salespeople, etc. So making sure that the workplace is safe beyond, in all of those places. And it might be that those staff are going to a particular place every day, or maybe every day for a period of time, or they may be all over the place, and you need to make sure that you've carried out proper assessments and put proper measures in place to address those various scenarios. So often when workers are in those scenarios, the risks can actually be greater. But your fundamental concepts still remain the same. So, we've got people going to remote locations. They may actually have greater risks than those who are in an office, for example. And there's a range of risks around accidents, and not just the accident, but in dealing with what if something goes wrong, but how do we deal with that if there's no one else there with them, or should there be no one else with them and they should be operating in pairs as a bare minimum. Security risks, so that obviously your staff could be put at risk. They might be going to other people's properties or interacting essentially with strangers. And social isolation risks, the same ones that we've talked about in terms of remote working, feeling cut off from the workplace and a lack of involvement.
Yeah, I came across a really good scenario once. A couple of tax inspectors went out to visit a farmer. They wanted to catch up with the farmer just to talk to him.
Sure they did.
What they didn't realise is the farmer was out in the paddock shooting rabbits with his shotgun.
Oh.
And so these two tax inspectors went out and approached him while he was out in the paddock.
Yeah.
Came up behind him because he turned around with his shotgun. The two tax inspectors approached him, and I'm sure they filled their pants.
Yeah, well, that may be a common response given those times. You don't know. So the key to managing these risks is maybe ring the farmer up before going out to visit. Is common sense, really, and along the lines of what we've talked about with other matters, engaging and consulting with those workers when looking at the hazards they're coming across, and looking at whether there need to be measures put in place to address them and whether they're adequate if you've got them in place. Having proper systems for reporting, making sure that you're following up on that too, so that if something does happen, you're able to respond. There might be a little quirk that happens, and actually you could put some improvements in place because, realistically, some things do crop up as you go about your work that perhaps may not have been completely anticipated. Making sure that workers are fully aware of the processes to follow, including when there's an incident. In getting that proactive culture, because you're relying on those workers to tell you as well a lot of the time, if they are out there and you're not. But also having some regular site visits in the same way that Anthony mentioned, and things, obvious things like PPE and things like that. It's the lack of immediate supervision in many cases, and sometimes a bit of complacency can fall in, and getting that sense of self-responsibility. There are, of course, tools that you can use, and before we sort of touch on that, there's the obvious sort of big risk around vehicle use, and we talk to a lot of people about the practical aspects around vehicle use. So just sort of minor, as a minimum, complying with road traffic law is absolutely has to happen, but it often goes beyond that, particularly where the organisation is providing the vehicle. So it's, things like making sure that all the required checks are done on vehicles, your warrants and your registration, and that the processes are in place to make sure that those are checked, and the more vehicles in place, the harder that can become. Obviously, where you're using larger vehicles as a part of the business, then things like pre-start checks and things like that are really important to have in place. Worker behaviour around vehicles is really important. Things like making sure that they don't speed, because the data is that the more speed there is, the higher the risk that they could have an accident. So in addition to your maintenance type matters, creating that culture. That sort of feeds into that GPS point. It's very commonplace now for vehicles owned by organisations and companies to have GPS tracking. It's important to have some policies around that, and if you have it all spelt out, then it means that you can use that GPS tracking to monitor the health and safety matters quite easily. Many organisations get the reports if staff go a certain number of kilometres over the speed limit, and we've been involved in a number of disciplinary matters over those types of issues, and in fact even employees not being where they're supposed to be. One guy went home for hours and hours in a day. Pretty stupid really when they know they've got GPS tracking, which is an important aspect of course of all of that. And there can also be other technology, particularly in larger vehicles, around alarms and things like that to deal with fatigue as well. So there's quite a lot moving in that area in terms of technology to assist.
I've done a very interesting case, which I can share with you, involving GPS and the Privacy Commissioner, which went on for determination. It was an employee who had private use of a vehicle outside of business hours. Not uncommon. He's in a sales role. The reports showed the employee skiving off, as you could imagine. He was off playing golf days when he should have been working, and his timesheet didn't match up with the GPS printouts. Not a problem there. What his complaint to the Privacy Commissioner was that he was being monitored outside his business hours. And that's a tricky issue for you as employers. To what degree and at what point do we switch the GPS off so that in their private time you are not monitoring them? Fortunately, for the client I acted for, they weren't monitoring outside business hours, and the Privacy Commissioner threw the case out. So, but that's just something to be alive to if you are going to monitor, and whether your policies will cover outside of business hours GPS.
It's really important, isn't it? It comes back to your documentation and what you've told them.
Absolutely.
And I had one where there was a company car being used all over the place and all hours of the day and night, and then the employee wasn't coming to work on time, and really demonstrates the importance of sitting down and making sure you follow a process when you're raising these things. In that case, it turned out that the son of the employee was actually having a few troubles, and he was taking the car without permission, and he was the one driving all these locations, but because of the family issues that were going on, that was the excuse for being late to work, which in the end didn't become incredibly significant. So it is, it can throw out a whole heap of issues. Other things, in terms of that technology, if we're going to remote areas, a lot of employers have spot trackers, the GPS trackers, and require their staff to have those on, once again spelling out clearly what they're doing and why. But if it's about that safety element, health element, then usually there's a way to do it, provided it's reasonable. This is the fun topic. Anthony gets this one.
The short straws. The office party. We all like a social event. What tends to go with social events, we all know, is alcohol and a whole range of other issues. Christmas party is the classic. Employment lawyers like Amanda and I fear those first couple of weeks in January when we come back to work and all the sexual harassment complaints come in.
Or even the weeks of December.
It's just not uncommon, regrettably. Anyway, so I'm going to talk about the social events, and you know what, it comes back to those same basic things, having good practices and policies in place. Good practice for employers is when you're having a social event to designate responsibility for supervising those events. Identify that person. Who's it going to be? They make the call. you pre-agree that if Amanda comes to me and says it's time to go home, it's time to go home. So while everybody's sober, we have that agreement. And those kind of things are really important. What if people do become intoxicated or even disorderly? And those kind of things do happen at events for a variety of reasons. People let their hair down and just go over the top just a little bit. So if you want to prevent those, put in place some mechanisms to deal with it. And it's also very important that Amanda stays sober at those events and tell me to go home and bear that in mind. So, yeah, somebody has to play that role. Keep in mind that if you are going to provide a free bar for the night, then you'll understand that the consumption of alcohol will probably be significant. You're going to need to provide food. You're going to need to be a responsible host as an employer. So, and what does that mean? Well, if you've got people that have been drinking, you certainly don't want to allow them to drive home. That would be irresponsible in my view. So you may need to provide taxi chits. A lot of employers are resistant to that, saying, what about the cost? At the end of the day, that sort of cost is cheap, in my view, for somebody to get home safely from a work function. So I can encourage you, if I can at all, to put in place those kinds of things. Look after your people. It is your work event. It's tied to your work. It's tied to your reputation and a whole range of things. So, and the staff notice that, to be honest. So you need to have that in mind. It's no different to employees coming and going from work, travelling safely. Deal with it that way. Encourage your staff to drink sensibly is another thing. So if you are going to have drinks in the workplace, you may want to put cut-off times. I certainly know we have that here, a curfew. If we have Friday night drinks, a partner will be here for a period of time, and at 7 o'clock or whatever the time might be, that's it. And if the staff want to go out clubbing or whatever it is after the event, well, that's over to them. But you make those sort of things very, very clear. Liability for harassment. Well, if it's the Christmas party, as employers, you'll be liable if there's a complaint of harassment or sexual harassment. So you need to keep that in the back of your mind. So that's the importance of managing those functions well. Again, you're going to need to have a policy in respect of that and make that really clear to people before the function that, look, if there is complaints, this is how we're going to deal with it. Remind people before the function kicks off. And I tend to do that, or have in the past, in written communications to all staff, 3 or 4 days before the event, so that everybody's really clear and you've reminded them that they need to behave themselves, but also have a good time. Yeah. Okay. That's all I wanted to say on social events.
Right. So I sort of pivot to continue the language to the cases that have come out regarding COVID, the COVID period, because many are interested. It's something that we have all complained that there's been no law. So when there becomes some law, it's always interesting to talk about it. So the first case that came out was on a pretty confined point. So that's Raggett and Dove Hospice. So on the 25th of March, the hospice sent a memorandum to the staff saying quite a few things, but the main bit being from 30 March, staff would be paid 80% of salary and wages until 22 April. Now, if you recall, 22 April was at that time anticipated to be the end of lockdown, or lockdown was at least until 22 April. They then entered into a restructuring process, and these applicants were eventually their roles were eventually disestablished, but they challenged that and also the decision to reduce the wages to 80%, and it was just the decision to reduce wages to 80% which was considered at this point. And the authority determined that the employees had not agreed to that, and if you remember the wording of the memorandum, there was no consultation, it was just a directive that that's what's happening. Which is, when you applied basic employment law at the time, as we did, that wasn't the right thing to do. But it was potentially influenced by the wage subsidy wording, and some employers got quite confused and thought employment law went out the window. So in the absence of consultation or agreement to vary the terms of the notice period, so because this reduction in wages related to the notice period, then there was no legal basis to reduce that salary under the employment agreement during the notice period. So there was an order to pay the balance to the employees during that period. So that makes sense, and the rest of the matters were to be heard separately. The second case that came out was Sandu and Gate.
Just before we jump into the second case,
sure.
What I thought was really, really important in the Dove case, and it's not an unusual principle, the obligation to consult in good faith with your employees when you want to make change. Doesn't matter what the change is. And that's all this was here.
Yes.
I don't know, most employers in this country reduced wages during the COVID period.
Yeah.
The key was, and that was our advice to all of you, consult with your staff before you make change. Give them the opportunity to comment on it, and nothing startling there.
Yeah.
So not surprised with the outcome of the case.
No, not at all.
And so good lessons for those that didn't consult.
Yeah, definitely.
Sorry.
No, all good. So the Sandu and Gate case was very minimum wage focused. So Gate provided essential services and so could operate during the lockdown. And I think that's also important in the context of this decision. So, but they did partially shut down operations because they were an in-flight catering service, so obviously didn't have much work and received the wage subsidy. And it proposed a partial close down and some documentation to staff that they would be paid 80% of their normal pay, and that employees could choose to use their annual leave to top that up if they wish. So once again, not an unusual aspect being put forward. And the next day they emailed all staff confirming it was doing a partial closure and offering a variety of options around the pay and taking of annual leave in different combinations. So, but shortly after that, so 1st of April, you'll remember the minimum wage increased, and initially Gate told the staff that it's only if you're attending work that you're going to get the new minimum wage rate. And those who are not rostered to work are going to get 80% of their wages based on the old minimum wage rate. And the union kicked up a fuss about that and saying, well, that it was unilateral action taken by the employer, no proper consultation on that point, and failure to meet obligations under the Minimum Wage Act. And the authority said that the payment of 80%, even when they weren't working, was payment of wages. And so therefore wages are subject to the Minimum Wage Act. And so you can't agree to an arrangement where people have wages paid below the minimum wage, and made the point that these employees were ready, willing and able to work, which was a big argument that was brought through in the COVID lockdown period, and probably got more strength here because it was an essential service as opposed to an employer that potentially could have been prevented from working by the various orders from government. And so the authority said that employees were entitled to be paid both for the work performed and work contracted for, and for which they were ready and willing to perform. So it wasn't, they made specific point that it was not that they weren't working due to the restrictions of COVID, but they weren't working because of the direction of gate. So this is this point about it being an essential service. So I think that's an important distinction. So it's not something that employers need to be running around going, oh goodness, if we couldn't operate, were our staff ready, willing and able? That case doesn't go that far at this point.
Yeah. Now, the last case, Sollys Freight, an interesting case in that employees were made redundant during the COVID period. They challenged their dismissal on the grounds of unfairness and breach of the obligations of good faith. And so what was really interesting about this, it was a restructure. Obviously, Sollys was suffering a little bit in terms of its finances. It needed to make change. In essence, it decided to halve its workforce in the Christchurch branch. It believed it needed to do that. The issue arose around Sollys applying for the wage subsidy scheme. They seem to have got themselves into a little bit of a tangle over what they were telling the employees and what they were in fact doing. They, at one point, applied for the wage subsidy. They decided they would do a restructure to reduce the staff in the Christchurch office, and then rang MSD to say, can you take the names of the following people off the list for the subsidy? Well, you won't take a genius to work out that that seems to be predetermination. This is even before they'd gone through a process with those particular workers. So it's not surprising when the case came before the Employment Relations Authority for determination that they found that incorrect information was given to the employees concerned. The application to MSD for the wage subsidy was misleading. The reasons relied on were therefore not genuine in terms of making these employees redundant. And probably the most interesting thing from my point of view was, and I don't think this case actually goes so far as to decide this point, if an employer had applied for the wage subsidy, they were obliged to maintain those employees throughout the period. I think we'd probably tick and say, yes, that's probably a fair finding. The issue I'm alluding to is if an employer made a decision not to apply for the wage subsidy, but could have and may have been granted it, does that affect their duty in terms of being a fair and reasonable employer? We don't know the answer to that question yet. I'm sure there will be a case that will come before the authority for determination. On its facts, this case is really, really straightforward, nothing startling. The obligation of good faith and fair dealings applied, and Sollys was found wanting in that regard. It just messed up in terms of its process and getting its messaging right, and the authority found against it.
And the other thing that it tripped up on too, which is something that we've talked a lot about in terms of restructures, was no opportunity to comment on the proposed selection, way people were going to be selected, or sort of the assessment matters. So selection criteria is a really difficult aspect and something that gets omitted, likewise with the requirements around redeployment. Now, I won't go into it all, but just remembering that there are a lot of technicalities around restructures which are easy to mess up.
Yeah, they're very tricky, and selection is one of the trickiest grounds in a redundancy process. So, as you say, Amanda, when you are facing selection, it's wise to spend the time, pick up the phone, ring us. We'll talk you through what you need to do. But long story short, your criteria needs to be objective. The employees are entitled to comment on it. Of course, you can have some subjective elements to it, but principally that's what the court will examine, how objective was it, and whether employees were given a fair opportunity in the process.
Now we've probably got time for some questions if anyone would like to. There's a questions Q&A button. If you would like to ask any, I know it takes a few minutes for that to come through, so we'll just wait a few minutes to see if there's anything coming through. I think probably in wrapping all of that up, there's a lot around keeping your staff safe, and sometimes it can feel a little bit overwhelming to make sure that you've covered everything, but it's about being systematic, isn't it? And just thinking about all the various scenarios that your staff are exposed to, being aware of things like your family violence requirements and your health and safety obligations, and making sure you've got documentation that covers it, your policies and
it's the first place
changes.
WorkSafe will go to. What is your documentation?
Yes.
It's the first thing they'll ask when they walk through your door if something's gone wrong.
Yeah. And the biggest slide that employers take is not following their own policies and documentation.
Yeah.
You know, we always talk about don't pull your policies out when WorkSafe knocks on the door and blow off the dust because you haven't looked at them.
Yeah, they don't tend to like that.
No, not at all. Okay, well, there's no questions coming through, so we'll call it an end. Thank you, everyone. You know where we are, but our contact details are here. If you have any follow-up questions or any issues that you want to have a chat about, we're more than happy to assist. So thanks for coming today.
Goodbye.